Recently, the Delhi High Court permanently restrained a Bengaluru-based cake shop from using the name Face Bake, Face Cake, or any other Facebook trademarks for its products and services. The order was the result of a suit filed by Meta Platforms that owns Facebook. Face Bake was also using the same font and blue on white color scheme popularized by the social media giant. Brands fiercely guard their unique identity, as it is crucial for protecting market share. In a trademark infringement action by BMW, the Delhi High Court in 2020 granted an interim injunction restraining an e-rickshaw maker from using the mark DMW. In the Starbucks Corporation versus Sardar Baksh Coffee case, the Delhi High Court in 2018 granted interim relief in favor of Starbucks and directed the defendant to use the name Sardar Ji Baksh for their 20 new outlets until the final hearing. The final result was that the defendant had to change the name of all its outlets to Sardar Ji Baksh Coffee & Co.
Where does the problem start? It starts from the fact that your original brand name, in this case, say Make My Trip, the words make, the word my and the word trip, none of them is unique. So you do not actually have protection or individual words being used which come together to form the brand name. The only way out is if you have a unique design or a unique logo or unique color combinations which can create a stronger IP which cannot be copied, because words alone can always lead to problems because none of them or most of them are normally not unique. But if you have created words, for example, Groffer, Gorffr, now that is a word which is not easy to copy and is therefore patentable or, at least be converted into a valid IP. So when looking at brand names, you got to be very clear that you must have something in your brand which is unique.
A brand name and logo are legally called trademarks. A trademark denotes the distinctiveness and integrity of a business. For the consumer, it also acts as a source identifier for the brand's offerings. Registering a trademark or even using one with or without registration gives the owner of the trademark certain rights. Subsequently, no other entity can register or use an identical or confusingly similar trademark for identical or similar offerings, unless they are authorized by the original proprietor. The Trademarks Act 1999 is the law that protects trademarks in India. It lays down the rules for registration, protection, and infringement penalties regarding trademarks. The misuse of trademarks across several e-commerce portals has seen companies across all scales fiercely guarding their IP rights, especially trademarks. One result of this has been that the total cases for trial during the given year under the Trademarks Act 1999 have been rising at a fast clip since 2016. However, as an indication of how challenging this area is for companies and courts alike, the pendency percentage has averaged above 95 between 2016 and 2020.
Now, most of these battles, when it comes to trade names and trademarks, are over at the interlocutory stage. So the real battle that you are fighting is getting an interlocutory injunction that is stopping the person immediately from using your brand. And that's where courts are very, very fast. Ultimately, the trial is going to take a long time because it is a process, right? You have to lead your evidence, you have to make out your case for damages, etc. But once your interlocutory relief is granted to you, half your battle is won. The second aspect is that there is a new statute which has come into force, which is the Commercial Courts Act, as we call it, by virtue of which intellectual property disputes are treated as commercial disputes. And there is a fast track mechanism which is being set out under the statute. There are various new provisions which have come in by virtue of which where it is very straightforward and there is really no answer to a trademark infringement. Brand owners may be in a position to get a summary disposal of the proceedings also. And this has started now. It's a process, of course. It's likely to take speed.
However, Burger King and Burger Singh have been coexisting peacefully. Many pizza outlets with similar names also exist in the same space. Legal experts say that this is because terms like burger are wide and can't be associated with just one brand. Finally, The Office of the US Trade Representative recently said in a report that India remains one of the most challenging major economies when it comes to the protection and enforcement of intellectual property. This can prove to be a significant dampener. A business has to create brand recognition and value to thrive in a competitive market. This is achieved by way of trademarks. If India wants these businesses to invest in it, regulators must ensure that their hard-earned IP is protected.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.
क्या हाल?
मत पूछ यार, फिर से स्टॉक्स में फंस गया।
तो स्टॉक्स के साथ बॉन्ड्स, इंश्योरेंस, गोल्ड में बैलेंस कर।
इसमें बहुत तामझाम है।
तुझे 5 पैसा नहीं पता?
अब तो सबको पता है। 5 पैसा है ऑल इन वन अकाउंट। डाउनलोड 5 पैसा नाउ।
अब तो सबको पता है। Investing made easy and rewarding with 5 paisa. Investments in securities market are subject to market risks. Read all the related documents carefully before investing.